police officer leans into your car window and asks, "Do you have any weapons on you today?" Your heart jumps, your mouth goes dry, and in the next 3 seconds, whatever you say could either protect you completely or hand that officer everything he needs to search your car, arrest you, or use your own words against you in court. Most people either panic and overshare or go silent and look suspicious. But there is a third option, a smarter option, a legal option. And by the end of this video, you will know exactly what to say, what not to say, and why the law is actually on your side if you know how to use it. Stay with me, because this one could genuinely save your life or your freedom. Here's what most people don't realize. When a police officer asks, "Do you have any weapons?" that question is not casual small talk. It is a legally strategic question. Officers are trained to ask it because of how people typically respond. Most people immediately say one of three things. No, absolutely not. Just my pocket knife. I have a gun, but I have a permit. And here's the problem with all of those answers. If you say no, and the officer later finds something, even something completely legal, you've now created a credibility problem. Prosecutors love inconsistency. It doesn't matter if it was a forgotten multi-tool in your center console. That no just became your enemy. If you say, "Just my pocket knife," congratulations, you just volunteered information you were never legally required to give. In some states, that's enough to justify further investigation. You handed them a reason to dig deeper. And if you say, "I have a gun, I have a permit," in some states, that's required by law. In others, you've just triggered a mandatory disarmament procedure and a chain of escalating questions that rarely ends where you want it to. Here's the legal foundation you need to understand. The Fifth Amendment to the United States Constitution guarantees that no person shall be compelled to be a witness against themselves. That right applies the moment a police officer asks you a question, not just in a courtroom. The Supreme Court case Berkemer versus McCarty, 1984, confirmed that even routine traffic stops can produce statements admissible in court, meaning anything you say to that officer on the side of the road can and will be used against you. You are never legally required to answer investigative questions during a traffic stop beyond providing your license, registration, and proof of insurance, and in some states, identifying yourself by name. That is the legal boundary. Remember it. So what do you say when a cop asks about weapons? Here is the script. Write this down, screenshot it, memorize it. "Officer, I want to be cooperative and respectful. I've been advised by my attorney not to answer questions beyond providing my required documents. Am I being detained or am I free to go?" That's it. That is your answer. Let me break down why every single word in that sentence is doing legal work for you. I want to be cooperative and respectful. This signals to the officer that you are not hostile. It reduces the chance of escalation immediately. Courts have noted that non-confrontational demeanors matter in excessive force evaluations. You are not a threat. You are a citizen exercising rights. "I've been advised by my attorney." This invokes a legally protected relationship. Once you reference your attorney, continued interrogation becomes legally complicated. Under Miranda versus Arizona, 1966, once you invoke your right to counsel, questioning should cease. You don't need to have actually spoken to a lawyer recently. The invocation itself is what matters legally. "Not to answer questions beyond providing my required documents." You are clearly defining your legal boundary without aggression. You are telling the officer exactly where you stand. No ambiguity, no room for misinterpretation. "Am I being detained or am I free to go?" This is the most powerful question you can ask at a traffic stop. Under Terry versus Ohio, an officer must have reasonable, articulable suspicion to detain you. If they cannot articulate that suspicion, you have the right to leave. Asking forces the officer to make a legal decision on the spot and puts that decision on the record. Now, if you're in a state with duty to inform laws, your script changes slightly, and this is critical. Several states have what are called duty to inform laws. These laws require that if you are a licensed concealed carry permit holder and you are stopped by law enforcement, you must proactively inform the officer that you are carrying, even before they ask. As of 2025, states with mandatory duty to inform laws include Michigan, Ohio, Texas, Louisiana, and North Carolina, among others. States with no duty to inform, where you are not required to volunteer that information, include Florida, Georgia, Arizona, and Pennsylvania, among others. This matters more than almost anything else in this video. Getting this wrong in a duty to inform state doesn't just create legal problems, it can escalate a routine stop into something far more dangerous for you and for the officer. I've linked a state-by-state breakdown in the description below. Check it before you need it, not after. Now here's where most videos get wrong. Even in duty to inform states, the requirement is narrow. It typically applies only to concealed carry permit holders who are actively carrying at the time of the stop. It does not mean you must answer open-ended follow-up questions about every weapon, every location, or every circumstance. So in a duty to inform state, your script becomes, "Officer, I am required by state law to inform you that I have a concealed carry permit and I am carrying. My firearm is located in location. Beyond that, I've been advised not to answer additional questions. Am I being detained or am I free to go?" Clear, calm, legal, controlled. You've met your legal obligation and you've drawn a firm line at the same time. Now, here's where people make their second biggest mistake. The officer asks about weapons, you decline to answer, and then they say, "Do you mind if I search your vehicle?" This is another legally loaded question, and your answer, legally, should almost always be 4 words. I do not consent. Not, go ahead, I have nothing to hide. Not, silence. Not, hesitation. I do not consent to a search. Here's why this matters. Under the Fourth Amendment, you are protected against unreasonable searches and seizures. The moment you consent to a search, you waive that protection entirely. Evidence found during a consensual search is almost always admissible in court, even if the officer had zero legal right to search without your consent. The Supreme Court established this in Schneckloth v. Bustamante, 1973. If you say yes, everything they find is fair game. Full stop. But if you clearly say, I do not consent, the officer now must establish one of the following to legally search your vehicle. Probable cause, a reasonable belief based on specific articulable facts that evidence of a crime is present. A search warrant, signed by a judge, or a recognized legal exception, such as the vehicle exception established in Carroll v. United States, 1925, or an inventory search following a lawful arrest. And here's why this matters even if they search anyway. If an officer conducts a search after you've clearly refused consent and without one of those legal justifications, that's potentially an illegal search. Evidence obtained through an illegal search can be suppressed under the exclusionary rule established in Mapp v. Ohio. That means it cannot be used against you in court. Refusing consent does not make you look guilty. It makes you legally protected. There is a significant difference between those two things. Now, let's talk about something case law alone won't cover. The human element. Even when you're doing everything right legally, your tone and body language can either de-escalate or ignite the situation. Here's what you need to know. Keep your hands visible at all times. Before the officer even reaches your window, hands on the steering wheel. If it's nighttime, turn on your interior dome light. This one habit alone reduces risk more than almost anything else on this list. Speak slowly and clearly. Don't rush. Don't stammer. Slow, deliberate speech communicates control and composure. It also ensures that whatever you say is captured clearly on the officer's body camera, which matters if this ever goes to court. Narrate every movement before you make it. If you need your registration from the glove compartment, say, "Officer, my registration is in the glove compartment. I'm going to reach for it now." Then move slowly and deliberately. Never reach for anything unannounced. Ever. Do not argue, do not lecture. The side of the road is not a courtroom. You will not win a legal debate at 10 p.m. on a highway, and trying to do so only creates more suspicion and more grounds for escalation. Assert your rights calmly, then let the legal system handle the rest. Do not physically resist any order. Even if an officer is wrong, and sometimes they are, physical resistance escalates danger and creates entirely new legal problems for you. The rule is simple. Comply physically, challenge legally, in court, with an attorney. Let's run through 3 scenarios so you can see exactly how this plays out. Scenario 1. Traffic stop, no weapon. Officer, do you have any weapons on you today? You. Officer, I want to be respectful. I've been advised by my attorney not to answer questions beyond providing my required documents. Am I being detained or am I free to go? Officer, you're free to go. Have a good night. Done. Clean, legal. You never had to explain yourself. Scenario 2. Legal concealed carrier, non-duty to inform state. Officer, any weapons in the vehicle? You, officer, I've been advised not to answer questions beyond my required documents. Am I being detained or am I free to go? You were under zero legal obligation to volunteer that information. You violated no law. You did everything right. Scenario 3. The officer pushes back. Officer, why won't you answer me? You hiding something? You, officer, I respect your job. I'm asserting my constitutional rights. I am not being difficult. I am being legal. Am I being detained or am I free to go? Stay calm, stay on script, do not deviate, do not explain yourself beyond what you've already said. Repetition is not rudeness, it is discipline. Here's the bottom line. The law gives you rights, but rights only protect you when you actually use them, calmly, clearly, and correctly. The next time an officer asks, "Any weapons?" you now know that this is not a simple yes or no question. It is a legally significant moment, and you have a legally sound response that protects you, respects the officer, and keeps you in control of the situation. 3 things to lock in before you leave this video. 1. You are never legally required to answer investigative questions beyond your required documents. Fifth Amendment, Berkemer versus McCarty. That's your foundation. 2. Know your state's duty to inform law before you ever need it. It changes your script in a narrow but critically important way. Link is in the description. 3. Never consent to a search. I do not consent are 4 of the most legally powerful words available to you at a traffic stop. Write those down, save this video, share it with someone you care about, because knowing this before you need it is the only time it actually helps.